My name is Cruz. I represent the United States, the appellees in this case. The United States respectfully urges this court to affirm the district court's holding denying defendant's motion to suppress for the following two reasons. First, the search was valid under the search incident to arrest exception, and even if it was not, it was valid under the plain view or single purpose container exception. Your Honor, would you like a brief summary of the facts?
No.
Thank you. To my first point, the court should hold that the search was valid under the search incident to arrest exception because the area in question was within the defendant's immediate control at the time of the arrest.
On that aspect, what separates being under the defendant's control if he's handcuffed?
So, Your Honor, here the court in the United States via Abdul Sur has said that the search is, the area within the control is taken into account at the time of the arrest. So here it would have been accessible to the defendant at the time of the arrest, and thus it would be within the area of his immediate control. The facts in our case state that the gun was nearly 5 feet away from the defendant, and although he was handcuffed behind his back, his feet were not shackled, Your Honors, and thus he could have easily lunged or tried to move towards the gun.
Was the case closed at the time? Was it closed and locked?
It was closed, Your Honor, but there is a presumption of danger to every arrest, and the courts in Shimla hold that officers are not required to think that defendants will be wholly rational. So they could still attempt to make irrational attempts to evade arrest. And here this defendant had already missed court. He was already evasive to the law. So it would have been logical and reasonable that the officers could protect themselves from this defendant acting irrationally and trying to reach a gun despite the fact that it's in a closed container.
Were there any irrational actions prior to the officers searching the container?
There was not, Your Honor. He was compliant in this case. However, he was already a convicted felon. He had missed court, and his prior offenses were for a drug case. So officers are justified in their training to expect, especially offenders from drug offenses, to act presumptuously unpredictable and dangerous.
What factors do we have to consider as far as the officer's reasonable fear?
His reasonable fear came from the fact that this was a known convicted felon, so the immediate apparent danger of the gun is immediately apparent and also illegal. Also, there's already a presumption of danger within firearms. Additionally, here he is a known drug offender, so he could have been presumed to act irrationally or dangerous.
Now, I know you said he's a drug offender. Does that automatically mean he is violent? And if not, was there anything in particular about this situation or these types of drugs that were concerned?
Correct. The officers here reasonably believe that he was a methamphetamine addict, and there is a known dangerous presumption with that kind of drug usage.
Counselor, let's say that this court doesn't agree with you on the search incident to arrest. Let's say we think that it sides with the being under control. What's your main point on the single-use doctrine, or the single-use container doctrine, with regards to the tin can, the metal can that was holding the gun?
Correct, Your Honor. Well, there is, so to my second point, although a person generally has an expectation of privacy to items he places in a closed container, some containers so betray their contents that they abrogate such an expectation. The court has held that the court has announced that any container that so clearly announces its contents, whether by a distinctive configuration or its transparency, otherwise it's obvious to the officers what the contents of this gun is. So here this container had features that were very distinctive to a gun case, as well as a latch that is unique to this wild gun case. In other words, no other container, no makeup or lunchbox is going to contain this latch, and these officers are trained to identify these gun containers. It was immediately apparent and obvious to these officers that this was a gun case.
Did it have the manufacturer's name on the container?
It did not, however, the exception does say whether by its distinctive configuration, so it is our position that this unique latch that no other container is going to have is the same as a label, Your Honor.
And what about sewing kit? Could it have been mistaken for a sewing kit?
It could not have been, Your Honor, because the officers were trained to identify these gun cases. They were trained to identify wild gun cases. They were trained by the distinctive configuration of the outside of the container as well as the latch. They knew a sewing case from Joanne Fabrics, for example, would not contain this latch or the configuration of this container.
On that regard, it sounds like you're asking the court to apply the subjective standard that's been used by a couple of the circuits, am I right?
Yes, Your Honor.
And this court's fear, at least my fear, would be if we use the subjective standard. Obviously, officers get trained differently across the country. Officers in Alabama get trained differently than officers in New York. Wouldn't the Fourth Amendment and wouldn't this exception be applied on varying degrees based upon how horrible or good the training was?
No, Your Honor. No, Your Honor. Adopting a layperson perspective would be more unpredictable and lead to more inconsistency than adopting a subjective viewpoint. Officers are trained for a reason. They're trained to identify these cases. If we were to adopt a layperson perspective, an objective perspective, who is this layperson, Your Honor, and what experience would they have? The experience that they would have with gun cases would vary. And additionally, asking officers to adopt this perspective would ask them to act unreasonably in the sense that they would need to forget all of their experience and their training and try to think of what a layperson would think that this container would be. I think that that's unreasonable for us to ask our officers to do. Thus more, we train them for the reasons of safety, and to ask them to forget about all of the training that they've obtained would be unreasonable and not good public policy.
Well, you know, I hear your position, counsel, but what about the issues of potential prejudices or pretextual, searches that these officers may do?
Could you rephrase the question?
Sure, yeah. So if an officer goes in and uses his or her subjective point of view and expertise, what's to stop that officer from making up things or ultimately laying something out in retrospect that allows
Your
us
Honor, the United States is not asking the court to adopt a bright line rule. This would be a subjective viewpoint would be a reasonable police officer. So the court would be able to consider and look at these on a case-by-case analysis, and the officer would have to prove why it was reasonable for him to identify this gun case. Here, in this case, they have done so. They were trained to identify these gun cases. It had a unique latch and configuration, which the officers immediately identified to be unique to this gun case, a wild gun case.
I'm going to ask you a tough question, yes.
I think so, Your Honor.
Why didn't the officers just go get a warrant for the container?
Your Honor, these officers are placed in dangerous situations, and it would be unreasonable to ask them to leave and go and obtain a warrant to search this gun case, because at any point in time, this offender could have been irrational and tried to reach the gun, and it would put officers in a dangerous predicament to ask them to do so.
Counsel, I'm aware of the establishment, and recognize too, there are two officers on scene, the likes of one officer, supposedly could have stayed with the individual, and while the other officer went to see the warrant, correct?
That is correct, Your Honor. However, it would still be plausible, which is what the burden is required by the court, that the defendant could have attempted to reach the gun, and to ask officers to not put aside that danger or to not stop that danger would be unreasonable. In conclusion, because the search was valid under the search incident to arrest exceptions, and even if it was not, it was valid under the single purpose container exception to the warrant requirement, I respectfully ask this court to please affirm the district court's order denying defendant's motion to suppress. Thank you.